Good afternoon, everyone. My name is Cynthia Lee. I'm a Senior Court Research Associate at the National Center for State Courts in Williamsburg, Virginia.
And I'm Daniel Sturdivant, Data Officer for the Administrative Office of the Courts in Kentucky.
And today we're here to talk about public access to court data and how it relates to the NACM core competency of court accountability and performance. My job gives me a really unique perspective on this topic because on the one hand, I'm frequently requesting case-level data from courts for my research. In fact, right now I'm working with Daniel on 3 different projects that involve court data. On the other hand, I'm often in the position of representing the interests and concerns of the courts to other researchers and to federal agencies that want to get their hands on state court data. This presentation is pre-recorded, but Daniel and I are here today with you live to answer your questions. At any time, you can ask questions using the chat feature, which you'll find halfway down the page on the right-hand side. Our learning objectives today are to familiarize ourselves with the trends driving increased expectations of data openness, especially with regard to case-level data, to understand how data openness relates to the NACM core competency of accountability and court performance, to learn what researchers want and expect from court data so we can respond to those requests more effectively, to consider what questions courts should ask when you're creating or updating your data access policy, and to learn how a proactive approach to data governance can minimize risk while also broadening access to court data. This morning's data governance session explained why better internal governance of your own data can help you, the court, as an institution. But why should the court want to share its data with researchers, the media, other agencies, legal professionals, litigants, or the public at large? There are 3 reasons. The first is public accountability. Today, it's not enough just to publish some performance measures on a dashboard or some aggregate statistics in an annual report. Researchers, the media, and the public need and expect to be able to use the court data to draw their own conclusions about what's going on in the courts. Second, to expand the body of evidence about what policies and practices are most effective, which can involve combining court data with data from other agencies or making those data available to outside analysts. And third, to comply with state and federal requirements regarding the collection and sharing of court data. Data is an important part of the story that courts tell about their work. It plays a part in communicating how well the courts are performing, it helps to build public trust and confidence in the courts, and it demonstrates to funding bodies and the public that the courts are using public funds effectively and efficiently. So public access to court data began with the movement towards performance measurement. Performance measures and public access to court data more broadly enable court leadership to, first, identify and correct inefficiencies in their processes and procedures. Second, to provide objective, empirically grounded support for their policy decisions. Third, to make court operations more transparent to the public. And fourth, to attract funding for court programs that we can show to be effective in improving people's lives, increasing access to justice, reducing crime, cutting jail and prison costs, or producing other quantifiable benefits that we can discover through data analysis. So performance measures started back in the 1970s and early 80s with time standards. Then came the trial court performance standards, the state court guide to statistical reporting that focused mainly on aggregate statistics, and then the court tools performance measures. A decade ago, all of this evolved and coalesced into the high performance court framework. So the high performance court framework focuses on the quality cycle. Data figures in throughout the quality cycle. For some problems, court staff may be able to collect and analyze the data themselves, but for more complex problems, it can be necessary to bring in an outside researcher. So the quality cycle starts with identifying the problem, and we can use data to help us identify the problem. Next, we collect data to learn more about the problem, analyze the data to figure out what's going on, take corrective action in the courts based on what we learned from the data, and then evaluate the results and start all over again. So data figures in at each step in this process. So where does public access to court data come in? Courts first started publishing performance measures such as these time standards that Michigan publishes on their website for every single one of their courts. And courts also have been feeding aggregate statistics to the Court Statistics Project at the National Center for State Courts for many years. Beyond today, public accountability includes higher expectations for research, media, and public access to case-level data. So some of these projects are initiated by the court as part of the quality cycle or are required as a condition of grant funding. So for example, if you have a grant to fund your drug court, that grant may require you to do a program evaluation to demonstrate the effectiveness of this court in reducing recidivism in order to renew your funding or as a condition of the grant funding. Sometimes an outside researcher will come to the courts with an idea for a project that can directly benefit the courts. So for example, a couple of years ago, a colleague and I came to Daniel with an idea to get a National Institute of Justice grant to do a randomized controlled trial of different types of text message notifications to remind people to appear in court, to try to figure out what is the best information that we can put in those text messages to make them most effective in increasing appearance rates. And sometimes an outside researcher will use court data for purposes that benefit public policy more broadly. So for example, here we see the Legal Services Corporation is monitoring evictions in response to COVID moratoriums. So now I'm going to hand it over to Daniel, who is going to talk about evidence-based policy and interoperability.
Thank you, Cynthia. Where I'm headed with this is I want to cover a couple of the sort of national trends that are driving this increase in the interest in data openness among the courts and other institutions. What we got on the screen here right now is the Foundations for Evidence-Based Policymaking Act. This is a federal law that started out as an executive order in 2013 and then has moved into law officially this last year, 2019. The idea here is that all the federal data sets out there are required now to be used in this way that allows them to be given for interoperable evaluations of the effectiveness of the institutions. That means that if you have data coming from one agency, it can be transferred, combined with data from a different agency so that it can be evaluated by anyone inside or outside of those different agencies to see how they're being effective independently or together. There's going to be lots of different aspects of this in different state laws. There's going to be requirements that'll vary from state to state. So the federal example is sort of a kind of broader example of something that kind of fits the general pattern overall. But you'll find that there's plenty of instances like this in all the states. And I think that you'll see that there'll be more of this coming our way in the future. As an example, in the United States, there is an evidence-based policy mandate in our legislation that requires that agencies like the Pretrial Services Department, which reports to the judicial branch, it requires them to demonstrate their effectiveness as an agency. This is an agency whose responsibility is to ensure court appearance and public safety for folks who are in the trial process awaiting the final disposition of a criminal case. And so their funding is dependent upon them demonstrating their effectiveness at accomplishing these objectives of appearance and safety. And the way they do that is by telling stories with their data. The sharing of this data allows the agencies with overlapping processes to share their insights together. An example from Kentucky is that our court designated workers program has lots of interoperable data transferred automatically back and forth between themselves and the community-based services branch of the executive branch. What this allows them to do is that when a court disposition, for instance, requires that a child's parent's parental rights be terminated and the child goes into custody with the cabinet and the executive branch, there's an easier process to track this kid back and forth with the systems that involve the cabinet's data and our data, because we have these automatic processes running behind the scenes to allow the same data to be available to both agencies pretty much instantly. And this keeps there from being delays or mismanagement of other kinds. And another reason that this interoperability is pretty helpful is because you can only reach conclusions about a very limited set of fields and concepts using a single agency's data. When the data becomes interoperable and can be combined in any way, then we can get to more broader insights. If we wanted to investigate the opioid pandemic, for instance, then we might need to look at not only court data, but also public health information and see where these things interact with each other. And it can be done to some degree with aggregate data. For instance, if you know about the number of charges or specialty courts diversions in a given county, then you can use that in conjunction with county level information from public health. But when the data itself is fully interoperable, and you can get down to the individual of maybe an anonymous individual's data point and see what their public health outcomes are on the one hand and what their judicial branch outcomes are, the insights that can be gleaned from that analysis become much deeper and more insightful. And this kind of goes back to what Cynthia was saying, is that a lot of the analysis that we as core professionals can do on our own is going to be limited by our expertise and time and bandwidth. And we can get a lot richer analysis and conclusions when we involve external experts. And for the external experts to be able to perform this analysis, they need to have a path to access our data. And another reason that might be driving a lot of folks to have more interest in data openness is that it may be required. In some states, there are mandates that court records be made open to the public in a very broad, deep kind of way. Again, another federal example is the Open and Necessary Government Data Act. This is a sort of piece of the previous legislation I talked about before. And this requires that federal agencies keep their data in a system that is available to the public and machine readable. And just to quickly demystify that machine readable term, it kind of invokes these ideas of Terminator or whatever. But what this really means is that your data is in some kind of format where if you transfer it to somebody else who has their own software, they can still kind of make sense out of it and generate charts and analysis and do their own thing. So HTML, XML, your general spreadsheets, those all kind of count as machine readable. Barcodes, that's something that a machine can process and get the information out of even if a human can't. Whereas, printed pieces of paper, images, charts, and things like that are a lot less machine readable, though the note with that is that the machine readability of all these formats is improving because people are interested in getting those insights. So as an example, if you have some kind of data that may be sensitive or confidential or in other ways might be something you'd want to limit, having it in a PDF format is not something that will necessarily prevent a machine from being able to extrapolate data from it and perform further analysis. One quick note on this is that at least in the federal example that I've put up here, and I'm assuming in most other instances, the common sense rules apply. If it's a confidential data point, it stays confidential. Things that have secret clearance stay secret, and proprietary information stays proprietary. But the sort of sentiment that I'm paraphrasing here from Senator Brian Schatz is that everything else sort of belongs to the taxpayer. So there's this perspective out there that if the data was generated by a process that is taxpayer funded, then in order to be accountable to those taxpayers, then the data should be made available to them. I'm not a policy expert. I don't claim to know exactly which way this trend is going, but my expectation is that because of the added benefits of having this kind of data exchange available among agencies and to the public, that we're going to start to see more and more of these requirements. And so it might be a good time to start asking these questions of ourselves if we don't have these policies and procedures ready to handle this sort of thing. So now I kind of want to move to a point of talking about, on the one hand, what are the risk elements of data openness? And on the other hand, what are the kind of benefits to it? And so the reasons open data can be risky include the sort of bad interpretations that institutions have to chase after, difficulties with protecting privacy, and then costs, which we'll get to in a second. And then the idea that the financial element, there can be a cost and a benefit there if courts are able to use their data to generate revenue. And that's definitely a double-sided coin, so we'll get to that in a moment. But let's start with the bad interpretations. So these are things that anyone who's been involved in the production of statistical reports, I'm sure you've encountered these kind of things. Dissecting the word bad, it can mean a variety of different things. The first example I have here is, let's call it malicious or heavily biased agenda by the person who is interpreting the data. So if someone gets a hold of a data set or a report and ends up taking it completely out of context and going to the newspaper, you end up with some zinger headline, and the courts spend their entire time playing catch up to try and sort of guide people back to a more reasonable interpretation of this report. So it can be perfectly reasonable data. Once it leaves your hands, can go off and do anything. And a second note there is that this is something that might be worth considering for the courts, in particular for those where judges are elected. In my experience, we've had a couple of situations where there was a hotly contested election happening, and the candidates would request reports about one another to use in political advertisements. And it's only because we were able to put the dots together that we even knew that that's what these reports were for. Otherwise, they would have just looked like someone looking for some kind of benign statistics about a given county. So these are kind of considerations that should be kept an eye on for anyone working with data that might be related to an election or any public officials for that matter. A different classification of the word bad might be when someone isn't really working on a somewhat suspicious agenda, but there's something lost in the translation between how we might have presented the data ourselves and what others do with it once it goes to them. So maybe someone who doesn't fully understand some of the nuances about units of count, for example, might make a claim that they think is reasonable, but they're taking it one step further from what really makes sense in a given report. And so when that happens, again, it can be hard work for the courts to keep chasing after it and find ways to bring people a better understanding. And then there are these kind of purposes that data can be used for that we might have some kind of ethical issues with or other objections like that. The example that I've got here is that there's now AI algorithms out there that are better at predicting the outcomes in civil cases than the professional humans are. And if you pay for one of these services, then you can have a recommendation on what your chances of getting a favorable ruling are by location or judge, and lots of things that could be taken any kind of which way. And that's one of the more extreme examples of this. Another sort of caution with this entire topic of AI is that it's one of these things where it is a very powerful tool, but it always requires the human element of common sense to interpret it. And so that is an important role for the courts, if there are any AI-driven processes out there, is to know when to take them seriously and when to go back and kind of say, maybe that algorithm didn't get the right answer here. What else can we do with it to improve the situation? And as we move on, one side note on this, I know we're starting out with the risky things, and it's going to make data sound scary and terrifying, and I sort of put that at the beginning without considering, I don't want to frighten anybody away from this topic entirely, right? We're going to get to the solutions on these things, so no one should give up in despair at this slide. Then we can talk a little bit about the privacy concerns. There's obvious privacy concerns if you're dealing with confidential records, but even when you're dealing with large compiled groups of data points about public records, you can still run into privacy concerns that might not have applied previously before it was possible for someone to take 5 minutes and come up with an entire state's entire case history for 10 years and go through everybody's name and address from that data source. There's a concept that is talked about in a lot of policy papers on this about practical obscurity, and that suggests that a lot of the rules that we came up with to determine what in our records is public are based on the assumption that someone has to hop on down to the courthouse and look at a piece of paper to find the information on it. There may be different considerations once we start talking about the possibility of having instantaneous access to everyone's name who has ever been involved in a civil or criminal case that is not sealed or confidential. And so there's no one right answer to this. It's just something to consider as we make our choices about what level of openness and what path to openness we give to our data. A similar idea is the right to be forgotten. When we talk about expungements in particular, if we as a court system make our criminal data broadly available to external parties, and then at a later point there end up being expungements of those records, Do we always have a plan for making sure that anyone else who has received this data in the past will have a way of keeping up with what has been expunged? If you look at some of the websites out there for some of the states that have broad access to large sets of data, they have an FAQ section, and one of the questions that will show up there is, what do I do if my expunged case record is showing up in some third-party site that I can find on Google? And the general answer is not much. So it's one of these considerations that should be taken pretty seriously in this question. And we'll talk about some solutions and advice as to how to approach this question once we get to later sections of the presentation. And then now we can talk about costs and in terms of the court's financials as well as technical costs. The compilation of the data that you need to make some reportable data available in a shareable, machine-readable, open kind of format, it generally requires some extra IT processing beyond what you get when you just have somebody enter something straight into a case management system. And there can be costs in terms of the infrastructure to make that happen. And then likewise, there's specialized labor that is involved in getting the data from what comes straight into a case management system into some kind of format that can be used in reports. And this labor can be kind of hard to come by for the public sector. If you have folks that already have these skills in the organization, I'm going to predict in advance that they're already extremely busy and more is being asked of them all the time. And if you don't have this expertise in your institution already and it's something you're looking to find, it's one of these situations where the public sector is going to have to compete with the private sector to find people with those specialized skills, even if we're not necessarily able to offer the same levels of compensation. And when we talk about revenue as the sort of flip side of that coin, there are states out there that use the access to their data as a source of revenue. So there's instances where, in particular, private firms will have the willingness to pay for this data because they are able to do some processing on it and turn around and sell information from it. Maybe they're running one of these AI processes on it. Maybe they're, I don't know, doing other kinds of further information processing that someone else further down the line is willing to pay for. And there's an argument out there to say that if there's a private firm willing to pay for data that a lot of our work has gone into creating, maybe the institution creating it should receive some of the revenue that is obviously involved in this process where people have some demand for it. So maybe it's market efficiency, maybe it's arbitrage, maybe it's both. That's not a question that I'm going to tell anybody the final answer to, but it's stuff to think about. Other questions that go along with this is that if there is a revenue-based component to access to data, is that equitable? If the only people that can get a hold of it are giant firms, is that really something that should be encouraged, or is there some justice issue about having access for everyone else? That's a tough question. Again, I don't have the answer, but it's something to consider when coming up with these policies. And then another thing to consider is that if an agency goes through years and years of having a budget where large 6-7 figures come from these data subscriptions, what happens if some federal or state requirement changes that and says, now you have to make it available for free to whoever wants it? That could be an issue in some instances. And so now we kind of want to go to, we talked about at the beginning, what are the benefits of the open data for us and for the rest of the world? And we've talked about some of the risks associated with it. So how do we try and get away with having it both ways, right? So how do we maximize our accountability to the public, have efficient data processes ourselves, and minimize the risks associated with that? And the main keyword there is kind of a point back to the part A of this two-part presentation. The previous presentation about data governance will have gone through a lot of the basic ideas about if you have a plan for this, the more there is a set procedure for what happens with all of your data from start to finish, the less this kind of stuff is going to be scary. The sort of broad advice there, not to step on their toes too much in the presentation that already happened, is that the less the agency is able to, or the less the agency has to treat data like some scary mystery that only one person can understand or do anything with, the more the data flows throughout the entire business process and has rules and assumptions that are easy to follow for everyone, the more that everyone has the right access to the right amount of data in a way that they can understand to do their job, the better off the entire agency will be. And so there's plenty of resources in the previous presentation about that, and other resources available online from the National Center of State Courts and others. And those are kind of the big picture things. We're going to continue to talk about how some of these questions and strategies apply to data openness in particular. So the first thing to think about in this path, we're going to go through a series of questions. Like on this slide, the question here is, who makes strategic decisions about data? We're going to go through questions and offer maybe some tips. There won't be any firm answers, obviously, because every institution is different and will need to shape these strategies to their own particular need. But for this one, we can talk about the leadership involved in the strategic decisions about the data. If you don't have people in a leadership role making these decisions, someone will still have to make these decisions, and they may not be as consistent and efficient as you might want them to. So the most successful part of a larger data governance strategy will be to get this kind of stuff up from the beginning. The typical leadership roles involved in data governance would be the data officer and the data steward, who make strategic decisions about data overall, and then a role that is identified in the sort of boilerplate data governance suggestions from NCSC is the public access manager. This would be someone whose main role is determining what is the story of the public-facing data for the courts, who responds to requests, what are the data points that get presented on a website, all these kind of decisions. If you have a person filling that as their main function, that'll be a public access manager. This is something that not a lot of institutions are necessarily big enough for this to be one person's entire job, although anyone doing these things will stay quite busy. In Kentucky, for instance, this is part of my particular job. I consult with the Office of Public Information about it, but generally in terms of directing traffic on incoming requests and determining what data is available to whom, that starts with me and is kind of part of the data officer role in Kentucky. So it's not essential that everyone have a public access manager full-time, but these are definitely choices that anyone providing data to the public will need to make. Now we can move on and talk about the difference between a proactive and a reactive data stance. This sort of, it's kind of obvious where I'm headed with this, that the recommendation is to be proactive, right? But the distinction I'm making here is that when you receive requests for reports or data sets, is the work that is being done by the folks involved in this process reacting to the requests that are coming your way? Or is it something where your interests as a leader in the courts are kind of driving what data is given to whom, what is the emphasis, what are the priorities? The classic example in terms of business intelligence is the report factory, is where the analysts churn through the compilation of whatever reports are asked for by outside forces without really prioritizing their own thing. This is a guaranteed way for everyone to stay busy forever, and it will likely fill up the entire bandwidth of the people that you have available to do this kind of work and not leave any space to fulfill the objectives of your own court system. Maybe you want to produce a brand new annual report for the courts, and you'll need to have a way to prioritize that kind of effort instead of the requests coming from the outside requesters. The tips for making this kind of work in your own institution is that you have to kind of learn to say no to the external requests. There will always be those, and they kind of have this way of, they're an easy KPI. You can say how many of the requests you got to, how quickly they got done. But if you let that drive the ship, it's going to be the only stuff that anybody ever has a chance to get to. So learning, when to say no, maybe something is something that would be possible to do, but maybe it would take longer than the other efforts that you need to do internally. So the internal stuff needs to get prioritized. That's a kind of tough one. for the emotional well-being for the folks that have to say no over and over again, but it'll help you get to a point where, in the long run, the more internally goal-driven stuff you have, the more efficiently you're going to be more likely to answer these questions with something that you've already made for your own purposes. And the second recommendation from Kentucky is templates. These have made a huge difference for us. Is that if you find that you're getting the same kind of question frequently, or if your own internal users need the same information over and over again, having something that's as plug and play as possible, where all the assumptions are kind of made from the start, helps considerably. In Kentucky, the key example of that is that during the legislative season, every new bill needs to have the kind of financial statements behind it. So there's a local impact statement for what the local governments are going to have to pay for it, and the Department of Corrections will need an impact statement for their own budget in terms of anything that would affect criminal law. And so there's a couple of months where we get 2 or 3 of these a day, and changing it from a process where every single one was approached independently based on what the person said to where we say, if you do it this way, it'll be done in 2 days. Easy peasy. Then 99% of them go through this easy process, and we have a much easier time fulfilling a lot more requests way more efficiently. Now we have some examples of questions you might need to ask for different ways of reporting things. So we talk about, are there different processes set up in your agency for dealing with bulk data versus aggregate reports? Let's first talk about what that means. A bulk data request would be anything where one row is one record. So if it has a case number and you know the date of the case filing, the date of the case disposition, the type of case, and the next row is another case with filing date, disposition date, case type, you got bulk data. It can be confidential, it can be data derived from public record, anything, but when I'm talking about anything where it's one row per record, I'm talking about bulk data. And I've got an extra note here. This distinction isn't particularly relevant to Kentucky, but I've heard about it in other places, that there's an added distinction between what folks would call bulk and what folks would call compiled. So this might be a state where the easy go-to default option is the data extract. You go on the website and you say, I want to download the extract and get the data in some kind of predetermined format. That would be their bulk data. But when an analyst like Cynthia comes along and has a very specific research project where they want to do an investigation of one particular thing, and an analyst has to go into a database and compile some data that isn't part of this readily available bulk structure, then that's what a lot of folks out there would call compiled. For my purposes, there's not a great distinction between these two, as Kentucky doesn't have anything that is truly available by default that would be bulk, and so everything we do would be more like compiled. And so a lot of our choices are, there's sort of one path for bulk, and there's one path for aggregate. And aggregate would be the example at the bottom of this slide. The example of anything that's not bulk, where instead of looking at each case, seeing the dates, seeing the type, you have, during this year in this county, here's how many cases were filed with this type. So it's something that's doing summary aggregation, such as counts or averages or percentages. Any of that is what I would call aggregate data. So some of the decisions that you might want to make about bulk data are, do you charge for it when there's a big bulk data compilation, like the previous example of having something where you go to the website and says, for this state, this is our bulk data extract. If you would like to subscribe to it, there's a fee. And that's an option that can generate some revenue. If you have data that's ready to go in that format, it's easy to update, that might be a pretty good option for you. Question would be, is if you're charging for it, do you make exceptions for academic researchers, the media, other government agencies? Generally, the answer there would be yes. There's a question about, do you prescribe limits on the use of your data, and does that come with a legal contract, like a memorandum of understanding or a memorandum of access? Data storage and definitions and these kind of things would be stuff that you would talk about in an MOU like this. There's a couple more examples on later slides that go into more detail on that, so we'll come back to it. Do you have limits on the types of data that are contained in your bulk extracts that are made available? So for instance, is there specific types of requesters or purposes that are limited? In Kentucky, there is a prohibition of using almost all of our data for commercial purposes. So we provide it mainly for academic research or public interest or the media, but anyone who comes along and says that their purpose for getting access to our bulk data is commercial, they're probably not going to be able to do that. There's a question of what do you do when compiling bulk data that is derived from confidential information or personally identifying information from public records as well. So for instance, if you have case records of criminal cases and sentences or civil parties, do you do some kind of anonymization of the personal information that might be identified in there? Again, this goes back to the question of what level of access should people have to this kind of stuff that used to be publicly available, but on a piece of paper that you had to go to the courthouse to access. There might be some purposes where someone is saying, hey, I'm trying to do a study of evictions in a city, and so I need to know the addresses so that I can put them on the map. And maybe our MOU that comes with this data says, all right, you can have the addresses, don't publish anything with a single address identified in it, make your map kind of buzzed out to neighborhoods or census tracts or something like that. And that would all be detailed in our memorandum of understanding that goes with access to that data. The next question would be about the confidential records. If you're providing anything maybe about juveniles or policy research on your own outcomes for something that involves confidential data like juvenile records or pretrial processes, what further restrictions come to access to that data? And those would all be things that you definitely want to stipulate in the legal contracts for access to these data sets. So some tips from Kentucky. We have a memorandum of understanding boilerplate that is kind of the start for any of these bulk requests. I consult with legal about the specifics on how these kind of things should work. Anything that is somebody who comes along to us other than the process I talked about previously, where maybe the Department of Juvenile Justice gets access to data on this automatic interchange, that would have a different MOU from what I'm talking about here. This would be for policy researchers, other government agencies that are looking at maybe one giant extract a quarter rather than something that's automated. They would go through this MOU process with us. Our legal department always requires that they start the agreement. And so there isn't truly a standard, even though there is some kind of boilerplate, but there's the ability to kind of make different decisions as they come up. The example being previously what I mentioned about evictions. If we want to say we deviate from the rule about not including public or personally identifiable information, and we say we're going to put the addresses in there so you can do this particular analysis. In Kentucky, if we provide bulk data at all, it's free. And like I said previously, the commercial use is prohibited. There's an exception to that where it's not like the only way to get data is to go through this MOU process. There is an application that allows you to look up case records that there's different levels of access to, and some of them are available to, for instance, attorneys, and there may be a fee associated with that. There's lots of different configurations for access to there. But in terms of I'm giving you a pile of data as the data officer, it's probably going to go through this MOU process. This is a risk-sensitive approach that allows us to have what I think is pretty good control over the use of our data that goes back to some of those risky scenarios at the beginning. It's also very labor-intensive. So some of the work that I'm doing right now to provide this more efficiently is to kind of take some of the efforts that we've been doing in compiling data and make them more into this is probably the data set that you're going to get, maybe with a couple of tweaks, rather than having everything be its whole own original compilation. Now we can move on to the other side of that original question about the difference between bulk and aggregate and talk about the choices that you might want to make when compiling aggregate reports. So even when you're talking about fields where you're just counting things, there can still occasionally be situations where you come across privacy and confidentiality concerns. So I got a little snippet from the Wikipedia page about Robertson County. This is the county with the smallest population in Kentucky. So as an example, what if someone came along and said they wanted an aggregate report, which none of these MOU requirements apply to, about the number of domestic violence cases filed during March 2020, grouped by the race, ethnicity, and age of the respondent. So you end up with something that's got 5 or 6 different grouping columns in it and lots of really tiny numbers in there, where maybe anybody in Robertson County would kind of know who that is just by looking at the age and gender of everything. So it is possible for there to be privacy concerns even when you're talking about stuff that might be public record and stuff that isn't really a bulk data request that has specific information for a unique case. And another question to think about is when you're reporting aggregate reports like this, do you use standardized fields and definitions for everything? Sort of obvious answer to that is maybe it's something to consider. If not, what do you do when similar reports don't match? Even with our best efforts in Kentucky, if we do something this year, maybe we don't have great records or great memory of exactly what we did last year and it comes out a little bit different. So what do we do when somebody notices one of those differences and we have to kind of help them work that out? Or if you do have standards, again, the question kind of points back to the data leadership. Who's making the decisions about which standard to use, what the definitions should be, what are your labels, all that type of thing. Now, again, some tips from Kentucky. You want to have a reporting policy, public-facing, that says this is how we do it. We have this on our website, and it's kind of where I point people. If somebody says, hey, I want access to all the case records from Jefferson County, that's where Louisville, Kentucky is, I say, sorry, our agency doesn't do that. You can have either the aggregate report where I tell you how many cases there were of a given type, or we can start talking about an MOU with all those standard kind of rules to it. I've got this document that I can point them to so they don't think I'm making up on the spot because I don't like them. And then in terms of that confidentiality piece that I mentioned, we have something that's called the Stu rule. That Stu is not really Stu's name, but this person who worked as a staff attorney when this came up and is now forever endowed with his name isn't really thrilled about that legacy, so I've anonymized him slightly here. But the idea here is that even when we're doing a report of an aggregate, so what we got right here is petitions for involuntary hospitalization reported by year and by region. If there is a cell in which the number that would be depicted is less than 6, we hide it. And that's a good way of having a standard rule that works pretty broadly. And we can say that just apply the Stu rule whenever you're doing a report of confidential data. And that allows people to get pretty good insights as to what's going on without having the risk of providing too much detailed information about a given record through an aggregate report. And some more tips about how to move away from that report factory model that I talked about before, again with the templates, but maybe rather than responding to just individual requests for reports, you have standard reports online. So if someone comes along these days and says they want to know about maybe the number of eviction cases filed per county per year, hopefully I'll be able to point them pretty soon here to a report on the website rather than throwing this onto the queue for our analysts to compile as a new request. So the more you can kind of guess what people are going to be interested in, think about what the message you're wanting to send to the folks that are interested in your court's performance. The more you can anticipate what those questions are and provide them something that's already answering the question, the less of this is going to be this kind of report factory, endless labor for everyone. With our reports, what you can see there on the right is that we have extensive documentation that goes with everything. And this is, again, something that it reduces the likelihood of those situations where folks interpret it incorrectly. Again, it's kind of labor intensive. So the idea might be to move from a system like this to where you have maybe a cover sheet that goes to the report and then find the fields in there that also references a data dictionary that does all the work that this documentation is doing here without having to have that go through that entire laborious process every time. Next, we can talk about how do you handle requests for reports or requests for data. This is kind of overlapping with the question before about the public access manager. The questions here is when a request comes to the agency, who's the actual person that gets it? Who does the different work involved in compiling reports or data sets? Who approves of this? So once everything is ready, who makes sure it's okay to send out, that it follows all the different rules we talked about previously about labels and definitions and consistent fields. And how is the prioritization determined? I think in my experience is that no matter how much effort you apply to questions like this, once people are aware that they can start asking for things, all of that bandwidth will be used up and you start having to prioritize what actually gets done. So the question is, how do you make that prioritization among different requests that are coming at the same point? Maybe you favor the internal requests, maybe you favor government agencies, maybe things like that. Are there individuals who need to be notified about reports when they're completed or compiled? This is, again, that example about the election. So once we kind of got wind of the fact that those requests were related to this election, we made sure that we notified everybody who was involved in that, all the people up for that election. You know, like, we've compiled this report, y'all can both have it, that kind of thing. As a general plan, where I'd like to point Kentucky is to sort of, since every report we compile for an external requester is public record, I want to move it to where these things are just easily made available to everyone, in order to try and avoid any situation where it might seem like some of this information can be privileged or can be used to surprise someone, or other instances like that we'd want to avoid. The question would be, do you allow for the identification of different parties, of individuals in an aggregate report? So this would be, what is the pre-trial release rate for each judge in a given jurisdiction? You know, would you allow for a report to put the judge's name on that to show the comparisons between these different kinds of outcomes? Would you do the same thing for attorneys or complaining witnesses or other parties by name? Not an answer that works for everybody there. In Kentucky, I can tell you that we do not permit this, and it you know, helps keep things from being personal, but it also has this sort of weird advantage to the larger jurisdictions, because while we don't report by judge, we do report by county, and some counties only got one judge. So again, no firm answer on exactly what to do there, but definitely a question to consider as you start to make a data policy or procedure. And then lastly, if you have a pretty robust default option, maybe some templates, maybe some stuff online, who's making the choice, and what kind of choices do they make about when to decide, yeah, they've asked for something that's a little bit different, it's going to take a bit more work, we'll go ahead and do that, or we don't have the time or the bandwidth to pull that off, sorry, we can only make this default thing available. So who's making those kind of choices, and what are the choices like? Our tips for you here are that we have a process where we try and funnel all the reports through the research and statistics team, by having a group email and this button that's shown on the screen here on our website, where if you want to request stats, it kind of goes there. So if somebody else in the agency gets a phone call asking about a report, they usually get pointed to this website and they can fill out that form, makes things kind of standardized and keeps them all on an even footing. And again, I'm talking here, I think I mentioned this sort of ad hoc as I was going along, but if you have a system where you centralize the work of responding to the request and compiling all the data to your data specialists alone, those people will quickly be overwhelmed and start having to make trade-offs in terms of what they get to. They'll end up being the busiest people in your agency, and you'll end up having them spend a lot of time on this. So some of the things that we're kind of pointing back to the Part A presentation here, the ideas under the data governance system is that maybe by having different roles in your data governance, such as data stewards or distributed business intelligence, which we're not going to get into a whole lot here, so I'm just kind of plugging the other information. That's kind of ways where you can shift this labor away from the specialists and maybe get more bang for your buck as an agency. Another question is, who decides what of your data is reportable? So without the standards applied to your reports, maybe you're going to get inconsistent results like I talked about previously, like we did something this year, but we did something similar in the previous year. And because we didn't have a standard for it, we're slightly different this time. And now we've got inconsistent reports out there confusing people. So, you know, lots of obvious questions to think about there. One thing to point out is when your data is entered in your case management system or collected from whatever jurisdictions it's coming from, do the labels that are applied to it then match what you want to say about it in a report? Maybe you consider different units of count or iron out some inconsistencies there. So it's something to kind of watch out for and try and have a plan for in advance before it lands on you with a deadline. Is all the data entered reliably enough to be reported? So, you know, if you're a large organization with lots of different jurisdictions doing their own data entry, are they doing it similarly enough that you can compare the entry in one place to another? Maybe business processes are different. Maybe the case management systems are different. All these things can kind of contribute to, do you know that you're going to get the same answer when you push it together like that. And a sub-question of that would be, do you have instances where you need to watch out for the lack of entry or the entry of other or unknown, which can kind of cause havoc in your reports? Another question to think about is how far back in the past can the data be reported? So maybe there have been changes over the years in what's being entered, what's being collected, what the business processes in the courts are. So it's good to know in advance that any given data set can only go back in time to any given date, so that when someone asks for something that goes back 20 or 30 years, you can tell them what's actually available before that process gets too far underway. And the tip for making these kind of choices, I'm again pointing back to the National Center for State Courts documentation about data governance, is that you need to have a data governance committee for this. You want to have stakeholders from the business side. You want to have data specialists. You want to have other leadership stakeholders from your agency. If these kind of decisions are left only to your data specialists, you might end up getting kind of poor results, especially if your data specialists don't have field experience. They're maybe great at putting together reports and compiling evocative data visualizations and things like that, but they might not know exactly what the implications of the entry of other in any given context would be if there isn't input from the kind of folks on the business side who enter the data. And likewise, the choices they make won't necessarily reflect the needs of the agency if there isn't a way for leadership to tell them what the priorities are, what's the message, what needs to be communicated. And now we can kind of move to a question back about interoperability again. So what are some of the ways that you can organize your data to make it more likely that you'll be able to have it work with other agencies, other states, or your neighbors in the judicial branch? There's some systems in Kentucky where they have a lot of great data collection on their own, but maybe they don't have a shared identifier for the individual. And so the interoperability between the two data sets isn't very strong. A common example is that the court designated worker program in Kentucky does juvenile diversions prior to the filing of delinquency or status cases. And often they want to analyze their effectiveness at preventing future either offenses for the kids while they're still kids, as other CDW complaints, or once they grow up, the filing of actual criminal offenses. But this is one of these instances where the data set that we have great individual data for the CDW program, and we have great court data, but not a way to bridge the two between the two and say that this kid is the same person as was arrested in this court case. And a lot of that has to do with the confidentiality of this data, where once the diversion has happened, it's kind of supposed to go away and no longer point back to that individual. But we don't have a system right now that can allow us to perform even this anonymous analysis and get that answer. So, what are the kind of different ways that we can think about how to, get to that interoperability? And another point to add to this is that if you are part of a state or some kind of jurisdiction where maybe the whole state doesn't use the same data set, then you're already kind of familiar with this question in terms of whatever you're doing to get data to the court stats project, for instance. There's probably some kind of process in your state to compile data maybe at the Supreme Court level and deal with these questions of interoperability. So the first question to think about here is when you're entering or collecting the data to begin with. If the data is not relevant, if no one's ever going to look up this record or use in a report in the first place, then maybe it's not something that you necessarily want to enter in the first place. The second aspect here would be that this is the use of data for the folks that are entering it in the first place. They need to be able to have access to things that will help them do their jobs more effectively and more easily later. So they want to be able to enter stuff they need to look up again, reference for their processes, that type of stuff. And then the third is that what the data that's entered should be able to be turned into reports that communicate important information about the institution's goals. And then number 4 there is our data openness thing. It's that you want to be able to get from what data you have entered to having data in one of these common kinds of formats that can be shared around. And so, number 3 and number 4 aren't necessarily things that we would consider when talking about decisions about data entry. But when you're making decisions about data entry, you think about these kind of questions in advance, you'll be more likely to have an easy time of accomplishing reportable and shareable data further down the line. So tips from the National Center for State Courts on here. The main one for those folks in non-unified jurisdictions where something has to be compiled at the Supreme Court level, or for anyone who wants to do something independent with interoperable data among different agencies, the option for a data warehouse is probably the way to go about that. So that's a data structure that takes your data as entered in its own unique kind of way and runs it through an IT process to get it into a common reportable format. Further details on that, since we're not going to go into it in great detail here, further details on that in the policy documentation from National Center for State Courts on data governance. And then the NODS, the National Open Data Standards, National Open Court Data Standards are in particular excellent for this. It's the strong default option prescribed by the National Center for State Courts. It goes through what kind of information you need to capture for each case in order to make it part of a system that can be easily used by other folks that are also familiar with this NOD system. So the data can be easily combined with other states or other systems for analysis at the national level. And the kind of advantages of this approach are the attributes of being aspirational and divisible, which means that if you aren't able to accomplish 100% of the specifications of these standards, then that's not the end of the world. You can do the things that are easy to attain, find the improvement that works for you, and maybe not undertake the stuff that would be very hard for your agency until a later point. So all the pieces of NODs can be subdivided so where you can comply with this part and not that part. And it's all something where you can progressively move forward as you go without having to worry about complete compliance or non-compliance. And with that, that's kind of the end of our presentation. Hopefully, we've given you some information about things to consider about data openness so that maybe you can have it both ways, maybe to provide the accountability that we need from the court system and have a good, robust data system in your own jurisdiction, and also avoid some of the risks and pitfalls from along the way. On the screen, a couple of the references we talked about. There's the data governance information from the National Center for State Courts Court Stats Project that has information about all the leadership roles and choices to make in terms of data governance and in the big picture, which is what was covered in Part A of this 2-part series. And the first link there is NODS. That's the resources for the National Open Data Standards for courts. There's a shorter version for leadership that kind of explains the principles of it, and much finer detail that goes way down in the nitty-gritty for your data specialists. Lots of good information there. And with that, I believe that concludes our presentation. We shall see you in the chat on Thursday.